Kalpesh sir, am I audible?
Yes. Audible. Waiting for madam. As soon as she joins, we'll start.
Yeah,
Okay.
sure.
Okay, so Pooja Lakshmi also will be there.
Okay, sir.
Dear participants, we are waiting for the guest. We'll be starting in 5 minutes.
Hello, good evening, madam. Hello, am I audible?
Sir, you're audible.
Good evening, madam. Welcome. I hope बड़ा बहुत टाइम के बाद आप you are using WebEx, so that was yeah. You're muted. आवाज नहीं रही.
So, ma'am, your voice is not coming. Some kind of an issue. No, ma'am, you're not audible.
Hello. आवाज आ रही है? नहीं आ रही मैडम. We are not able to hear you. हेलो. बहुत कम आवाज आ रही है, बहुत कम. अभी अभी आ रही है बस. अब आना चालू हुआ. अभी थोड़ा बड़ा है. ओके. Yes, participant, you can give thumbs up. I think it's better. It's not, for example, good. Okay, so thank you very much. Sure, thank you very much. So, Pooja Lakshmi, please start. Over to you.
Yes, sir. A very warm good evening to one and all. I hope I'm audible. Yes, okay, ma'am. Thank you. So I invite each and every one of you to embark on this transformative journey of professional growth, collaboration, and innovation. Let's embrace the challenges and opportunities of 21st century, guided by the expertise of Abhinandan ma'am. Together, we can shape the future of legal education. Welcome to the first ever 1 month national level online faculty development program on teaching law in the 21st century, a collaborative effort between Law Teachers India and Gujarat Maritime University, Gandhinagar. This program is a testament to our shared commitment to advance legal education and prepare educators for the challenges and opportunities of 21st century. Today with us, we have our faculty coordinator, Dr. Sujana Iyer. I hope I'm audible. Currently working as an assistant.
Wait. Today is Vidhi madam is there. Vidhi madam.
Okay. Sorry, ma'am. Sorry for the confusion. Today we have Vidhi ma'am with us. Over to you, ma'am.
Okay, good evening, everyone. I uh, I hope I'm audible to everyone. Uh, Today we have with us, ma'am, and on a very interesting subject on strategies of teaching conflict of law in India, Indian law school. It's a private international law, so it's a very emerging area and it's an important area. Today, faculty must know how to teach the new pattern of pedagogy of teaching. So we have with us Abhinandan Bassi ma'am, who is an assistant professor of law and legal aid center, convener Rajiv Gandhi National Law University for 12 years. Her area of specialization includes legal methods, intellectual property rights, major legal systems, alternative dispute resolution law, child right, child rights related to women. During her career, she has published 7 research papers and has a research experience of 8 years. Moreover, she has presented over 30 papers at seminar and conferences and has 8 years of teaching experience. Over to you, ma'am. We all are eager to hear from you to learn the different pedagogies.
Thank you so much, ma'am. I'm obliged by your kindness. It's 14 years of teaching, ma'am. It's 14 years of being with Rajiv Gandhi National University of Law. I hope Kalpesh can correct his notes now. And conflict of laws was given to me. It is a different story altogether. Conflict of laws was given to me. Voice is not audible. Is it not audible to all of you?
It's audible. We can hear, but lower, but we can. It's fine.
So I hope it's better now. I'm
Yeah.
just trying to play because the internet is an issue.
Okay. That's fine as of now.
Dr. Rena, is it better now? The voice? I hope it's better now. So it's conflict of laws thank you Raman sir. Conflict of laws is has a different story altogether. Wherever I've been concerned or wherever I have you know intimated or the authorities of mine that this is give me a new subject to challenge new things or to challenge myself. I'll try and log in from the phone. Kalpesh sir, can you give me the rights to the other email ID? I'll log in from my phone. Audible? I am. Greatly. So my apologies. I'm trying to figure out what is best. I hope this is better now. Great.
Yes,
So,
yes, yes.
thank you, sir. Conflict of laws was given to me to teach as a challenge when I told the authorities that, we need to have different branches of international law. Because somehow from past few years, when we see our students going out to study abroad, there are so many topics, there are so many concepts that we feel as if we are unable to teach them because if you look at the papers which are getting important or which are getting a lot of importance now, there are we can talk about the idea of AI. We can talk about contemporary ways or contemporary topics of intellectual property rights. We see how arbitration has become so important, but what baffles me or what makes me um, you know, look back at the year like 6 years ago when conflict of laws was introduced as a paper, we never knew that it is so important. We could not understand. We always thought that, this is one paper which might not be, because when you look at public international law has two streams: public international law and private international law. Public international law concerns the governments, and we were looking at different governments being approached. We would look at different ideas, or we would look at different countries moving into trade or moving into different policy making. Wherever public international law was concerned, be it the sharing of the water, or be it the sharing of any trade strategies, we still could not, for the first 2 years when we were teaching it, we could not still believe the importance of conflict of laws being relevant at all. Because for somebody like me, I could understand that there is a lot of migration happening. But then during COVID, and I think a year before COVID, 2018 onwards, the amount of relevance that this paper has, or this paper has come up with, is amazing. Now WhatsApp allows us to share content. So give me a minute to share the document that I want to share with all of you. Okay, it has. I'm sorry. I'll have to mail it to them. My apologies. I wanted to open up a document, but I uh, so I'll give it to you towards the end. Maybe I'll email it to Kalpesh and he can open it up. Kalpesh sir, can I forward you the email? Would you be
Yes,
able
yes,
to
sir.
present?
Yes, yes, yes.
Yes. So what happens here is that conflict of laws. I have Pooja Lakshmi. Thank you so much for the intervention, but I only have Kalpesh sir's email address, and I want to forward it to include attachments so that Kalpesh becomes my Sarthi. Thank you, Pooja. You're such a blessing. We'll be grateful for you to be here. Kalpesh sir, I've just shared an email with you. Within that, there is a Word document um, for conflict of laws. I wish to bring it on record that the whole material that I've taken up is from the open sources. It's not something that I've written. It's something that I've compiled so that I can bring out different facets of conflict of laws in front of all of you. Because it looks like a very difficult paper, but it is not. It is a super interesting paper. It's a very challenging paper, and it allows you to play with the syllabus, with the curriculum so much that you can involve the students, you can involve postgraduate students, you can involve comparative legal methods as a paper into this, you can involve clinical legal education into this, because I take care of the legal aid clinic as well from past I think 11 12 odd years. And from past few years we've started looking at the international aspects of role playing and clinical legal education as well, because of conflict of laws. So when you look at and when you talk about conflict of laws, it's a misnomer. It's completely a misnomer, because there is no conflict between laws. What what has been established and what has been laid down is entirely created so that there is no conflict of laws. Rather than conflict of laws, the name of the paper should be no conflict of laws, or ironing out the conflict of laws. Because you look at so many regimes which are at loggerhead, or which are at fight with each other, because they want relevance over the other, and they're looking for a solution. We cannot undermine how relevant this platform of an option, or of the platform of an agreement between the parties, two or more parties, to create amicable solution is great, or is um, present, or we cannot be any more grateful than that. How can a paper be named like that for conflict of laws or no conflict of laws, sir? The paper has to be this, it has to be conflict of laws, or it can be private international law. But we really need to rename conflict of laws. We really need to take the negativity away from the word, because it is a very, very positive concept. We talk about law of contract. Yes, a law of contract is and law of torts, two very basic papers that we teach the first year students. When you talk about law of torts, and when you talk about defamation, publication of material which is defamatory in nature, or when you talk about the contractual obligation under torts, wherever there is going to be an old agreement, when you talk about nuisance, negligence, anything which has to be taken into account wherever the contract or the services of good is concerned. This is a compilation. I'll come to this later. I'll go back. I'll come to this explanation along with it, because if you zoom in, it talks about the two names of the paper, and it talks about the concept that how conflict of laws talks about the idea of removing the conflict from the laws, because public international law allows the states to negotiate between themselves. It allows the people to the statesmen or the citizens to talk about the problems that they have. But when you are involved with law of contract, when you are involved with a personal issue, imagine how restrictive you will be if your area of operation is only your country. Imagine how difficult it is going to be for you to break this barrier to trade with the other country without this pressure that in case anything goes wrong, who is going to come to your rescue? We have built up on these laws over a period of time, going back to Hague and Rome conventions. So this paper is an amalgamation of law of torts. This is an amalgamation of law of contract. This is an amalgamation of international law. This is an amalgamation of what you say. Kalpesh sir, can we take the questions in the end, because if that is going to break the flow of the thought.
Yes, yes, yes.
Is it all right,
Yeah,
everyone?
yeah.
If we can take the yes, thank you so much. I'll be grateful if you can just write down your questions in the chat box, and one by one, as far as I can, I'll try and deal with all these questions towards the end. So we have this amalgamation of all these papers together, all these topics together, and conflict of law gets created along with the aspect of arbitration into it. Because when you look at the conflict of law, it allows us to talk about private disputes. It allows us to talk about private disputes, and it allows us to talk about the dispute that the individual has with the individual. Imagine the amount of freedom that you have, amount of reassurance you have, that even if you're going into a trade, even if it is a economical policy that you're entering into, even if it is a simple e-commerce, even if it is a startup, look at the amount of strength you have, because there is a jurisdiction available to you. When you have bhaiya, please, when you have the idea of the conflict which is being taken away from you, that is the whole concentrated idea of conflict of laws. We are trying to neutralize the differences that have arisen between the parties. We try and look for a neutral place to talk about the differences that we have. This is why this paper becomes very important, because if you look at the idea now, our global alliances are dependent on international relationships. Our global trade is dependent upon international relationships. Our global concept of marriage, our concept of migration, our concept of immigration, our concept of surrogacy, international surrogacy, our idea of AI exchange, our idea of labor exchange. Everything that you look into the idea, look across, it is dependent upon international boundaries being diluted. So when international boundaries get diluted, we cannot forget the idea that every country will have its own parameters of laws regarding every aspect. Few ideas are international in nature, but those international ideas also require to be ratified by the country. There are so many agreements that we have not ratified as a country. There are so many conventions, there are so many principles, there are so many laws that we have not adopted, which are compulsory by international organizations if we wish to be a part of them. corporate social responsibility being one of them, which we've just introduced through different amendments of the law. Then juvenile justice being another example. Prevention of sexual harassment at workplace being another. Most importantly, your Information Technology Act being one of the predominant act which we created because of the international pressure. So when you talk about these boundaries being diluted, conflict of law becomes more predominant. Why? Because we have to understand the fact that there are different obligations involved. And when you look at the different obligations, why is it that the standard law has to be maintained? Because countries like India, we do not have polygamy. But what about the countries which believe in Sharia law and have polygamy? What about a private international individual? Sorry, what about a private law which is going to come into place when a French individual marries an Indian individual? What about the difference of age, which has the legal right of marriage? What about the divorce regulations? Is it if till the time that lady or that the other spouse becomes the national of the country where you have shifted to? What about the property which is going to exist as a matter of conflict? Within the property, you have another scope of movable property and immovable property. So there are so many jargons which are involved in every single day of an individual which has migrated to a different country, or which is inviting migration to their own country in form of any alliance, contractual, non-contractual, based upon property, not based upon property, based upon marriage, based upon any form of contract other than marriage. And for many religions, marriage also is a part of contract that we follow. So you have to see what is going to be the flow of conflicts. Then, being an Indian national, how is it going to work out for me if I want to apply for relief for domestic violence in England? What if I have to report a matter of personal injury or defamation in Brazil? What about what about a British national who has an act of corruption and malpractice against a company there, but comes for a for come from come, comes to India for trade and is spammed? We do not have ideas, we do not have laws related to corporate criminal liability. What is going to happen? What is going to be the central idea? So if you just concentrate that what are the few features of this is like fourth paragraph. I've bold the few words. I've highlighted them by the idea that there are some features that characterizes the discipline, some of the defining elements that can elaborate what actually is conflict of law. Because conflict of law, the first right as an individual that you have is the choice of law that you want to pick up. It is the choice of law that you wish to pursue. And when you talk about this choice of law that you want to pursue, it also involves the matter, or it also involves the fact that what is going to be after the choice of law, what is going to be the point of law that you're going to fight in. Because as I outlined first, there are so many different parameters which are involved wherever the individual is going to get concerned. Because it is just like belonging to your own country. Imagine you are having the similar interactions in the other part of the world. It is as simple as you being a tourist and going on and going away to a Disney, being be it in Hong Kong, be it in Thailand, or be it in any part of the um, part of the world. So when you are visualizing certain things, imagine being a tourist, getting nowhere address at entry. There is not going to be any code. So the application of conflict of law allows us to pick up one, the choice of law, which law you want to pursue, and most important, which jurisdiction to follow. This is the main crux, or this is our principle. A lot of laws associated with the centralized idea of corporate theory, the modern theory. We have the statutes with that, the idea of to get in. There are certain notion of when you are trying to frame the idea of concept of law as a curriculum, we have to be very sure that what is your central idea as a teacher. What is the idea whenever conflict of laws is involved? So when we devise the
Madam, sorry for interruption. Please, can
you scroll the paper?
I suggest just switch off your the video because there's a voice internet
Sir?
issues there. Video. Yeah.
Sir, what, sir?
Please switch off your video because there's a network. We are not able to hear you for last I would say 30 seconds. Please over to you. Yeah. वीडियो की वजह से थोड़ा नेट का प्रॉब्लम हो रहा है, सो प्लीज कीप योर वीडियो ऑफ, so प्रॉब्लम नहीं होगा.
Sir, better?
Yes. Please carry on. Yeah.
Thank you, sir. So I'm really sorry, Kalpesh, sir. This situation was not in our hand too. I'm trying my level best. I'm really sorry. So when you are trying to accumulate the curriculum, because curriculum becomes one of the most important aspect. So we devise one, the jurisprudential theories, because they formulate or they allow us to create the basis for understanding that why this particular um, notion is being followed. Why is it that conflict of laws is being picked up? Because you can the very first initiation, because we divide our syllabus into modules. So I'm presuming that even if it is not the idea of dividing your syllabus into modules, at least we can divide it into different readings, we can divide it into different notions that you want to present to, before your students. Because currently what we've done is, in my institute, we've shifted to a new trend of curriculum development, where two-thirds of the syllabus is going to be based upon theory, and one module, like one-third of that syllabus, is going to be dependent or completely guided towards it being a practical module. So we look at the different aspects or practicality, because when you look at conflict of laws, it enables your students to practice as immigrant lawyers, or law, practice the law of immigration, specifically related to transfer of property, ownership of property, citizenship, um, conflicts. And it allows us to create a safe haven for people from different caste, creed, and race to get married to each other with mutual consent. So we have to this is one of the papers which allows you to be very contemporary and very liberal with your approach of explanation. So when you talk about the jurisprudential or philosophical part, we only stick to the basic theories of conflict of laws, because the concepts are so much. Because wherever a country is going to get concerned, we try and cover what is the local law in that, and what is going to be the foreign law in that. So it is difficult to divide your composition into different countries, because initially when we started with the conflict of laws, we discussed it as the major legal systems of the world. So we had 13 different constitutions being discussed within that paper. But that paper became so bulky for the students to memorize and to understand, because at the end of the day, what was the drawback of that paper? We were unable to teach them the comparative law, because comparative public law, constitution, we agreed that was something that the students could understand, because it was easy for them to read the material under one roof. You give them the PDF of the constitution, or you give them the explanation, or the practical approach, which to study how to study those hefty constitutions of different worlds. But then they failed to understand the comparative analogies which were protecting an individual. Because उस तरीके से the only thing that we were able to convey to the student was public law. So we converted that into a different paper, comparative public law, which the postgraduate students would read, because we would take it for granted that now they do not need to look at the jurisprudential aspect of that particular paper. And then when we kept refining and redrawing the parameters of conflict of law, we started dividing it into the heads of the choice of law and the point of law which is applicable. So for the choice of law, along with the local courts, we introduced arbitration as one of the components of study. And arbitration became one of the most important ideas, because wherever conflict of law is concerned, it brings into the picture the conflict of forums as well. So law of contract, you look at the Vodafone case, we look at the e-transactions of the Caribbean islands, we look at so many examples that we have, with where we have these little pockets of tax haven, and we have these little pockets of uh, you know transactions being safe, even though they might not be according to law. So we are always looking at neutrality, and wherever there is going to be a benefit of time and money and convenience, people are always going to follow that. So forum shopping is always going to be the drawback for conflict of laws, and we wanted to address that. So it allowed us to talk about the local laws, because in the previous couple of years, because of arbitration, we could see a lot of deliberation from the apex court related to the participation of foreign countries into our trade, specifically refineries, and other areas of wealth. So arbitration being included as a part of the module of the curriculum allowed us to talk about international commercial arbitration, the UNICITRAL model, the New York model, and how our act and the other institutions create, institutional and ad hoc arbitration. So the basic idea, because conflict of law was introduced to the second year students in the 5-year law course that I teach. And in the traditional course, because I'm a student of the traditional school, we were not taught conflict of laws. And I clarified it from another university of mine, which is in the same district. They still do not teach conflict of laws. They just teach international law as a standard subject, and private and public international law as specific different branches as is not being pursued. So it is one of the drawbacks that we face, wherever the approach is going to get restricted. But even if you are teaching international law, it can allow you to present or demarcate certain area for public international law and private international law, which can be easily handled by conventions. We cannot we'll get restricted by the idea of space, because you will not be allowed to expand and talk about things in detail. But nobody will be allowed to stop you from discussing every single thing briefly in summary, so that at least one basic notion, maybe in future they can do their specialization in international law, specifically private international law, and the law of obligations. And this will allow the students to at least get the purview of this paper. In case you can have international law, if you're teaching international law and there's no scope for public or private international law to be taught. We are blessed in a way when we talk about 5-year law, because every second year our syllabus gets reviewed, and there's a committee which allows us to incorporate all the contemporary and the new challenges and choices that we wish to include in the part of the curriculum. So arbitration was the first point which we addressed, because we wanted to address the fundamental question, specifically the interference of courts and forums, because the English courts were ordering orders which we had to follow as being the receiving party, and the jurisdictional dimension of the receiving party, or the party at loss, wherever the appeal would go wrong or appeal would not get approved. So arbitration initially with the jurisprudential aspect, then with arbitration, and then we divided the point of law which was under conflict. So we gave equal weightage to property and marriage, because these were the most important components that we faced wherever the individual conflict is going to was involved. So within marriage, we discussed the idea of divorce. We discussed the idea of property rights. We discussed the right of nuptial rights, which would belong to the spouse. We discussed the idea of succession. We discussed the idea of guardianship, because in case something happens to the parents, uh, which side of guardian is going to get privileged to take care of the children, which gets privileged to take care of the um, the minors in case of any mishap or clashes or separation for that matter. So then we gave equal importance to property because it allowed us to address contracts. It allowed us to address contractual obligations because it allowed us to talk about movable and immovable property and contractual obligations, along with again ownership and transfer of property, because transfer of property also becomes one of the point of conflicts wherever the individuals are concerned. Because time and again I will go back to the same 2 points, my dear friends, that one, that the conflict of laws is related to the fight and the conflict of legal rights of individual versus individual, and second, that every territory will have its own rights to address that individual fight. So if you belong to that territory, it is something that comes with your citizenship. But if you have evolved as a citizen in that particular place by virtue of any law or any private what you say, ritual, marriage or succession or transfer of property, because in Europe also, if you own in certain countries like Italy, and if you own certain property, you become eligible to apply for temporary residency, and which gets renewed every year on terms and conditions. So Croatia or smaller countries, it allows you to access those. Then you have the idea of property. Along with that, we had we further subdivide into your succession property obligations, and later on we added mercantile law or law of contract also, which allowed us to talk about the e-commerce, which allowed us to talk about the significance of e-transactions, which allowed us to talk about the exchange of human resources, which allowed us to talk about different parameters of goodwill and contractual obligations being exploited, negotiated, and for every single thing, be it marriage, be it property, be it citizenship, be it ownership, be it contractual obligation, or be it any point of law, we could go back to arbitration as a forum. We could promote online arbitration, we could promote institutional arbitration, we could promote ad hoc arbitration, and along with that, it allowed us to promote international trade organs like WTO and WIPO, World Intellectual Property Organization, and World Trade Organization, because both of them have superior institutes dealing with arbitration, specifically WIPO's Arbitration and Mediation Center, and all the trade disputes which could amicably be resolved through negotiation, mediation, and arbitration. So it allowed us to promote two different things at the same time. Arbitration, because arbitration allowed us to overtake forum shopping, because when you are trying to teach young lawyers, what do? You try and teach them probably something which is right. So one way of taking care of forum shopping, because that is the biggest disadvantage of conflict of laws. So it allowed us to connect to simpler, easier, and cheaper methods like negotiation and mediation. And arbitration being a part of this syllabi, my dear friends, it allowed us to bring in clinical legal education also, because we would create panels of students as countries, as judges, and introduce matters of private dispute to them. So, be it contract, be it trade violation, be it cargo, being dumped at a particular place, be it anti-dumping duties that they wanted to fight, be it the custom regulations that they wanted to fight, be it the divorce that they wanted to file. So, we would place two different countries. This allowed our students to learn public, that is the constitutional part, and the legal aspects related to that particular law point also. So two things they could three things rather. One, they learned clinical legal education, role playing. It became more interesting for them, because at times we would see real fights in the courtroom, and it would be it would get difficult for us to separate the lawyer from the role player that was existing there. So slowly and gradually we've built up this paper in such a manner that you could involve so many things into it. And arbitration is one factor which allowed us to do it very brilliantly. That is the advantage, the biggest advantage as a teacher that I've received by introducing arbitration into uh, this particular paper. And when you talk about the different points of law, or the different disciplines that we wanted to achieve, so all the five parameters that the paper has is that, what choice of law that you want to follow, what is the rule to direct that particular resolution or solution to you, what about the law that is going to be chosen, and what about the after effects in case you're not happy with the decision that has been given to you. So this particular module division of arbitration, conflict of the contractual obligations, marriage, property, it allowed us, and the jurisprudential aspect of conflict of laws, it allowed us to bring out the holistic approach of the paper, including the practical aspects which were required to be co-joined. Because when you talk about the civil legal systems, there were so many questions which the students could answer. And when during COVID, when we could not do we were dependent on the online teaching, this paper gave us again a very great platform of research of projects. So we could not undertake clinical legal education or role playing during that time. So rather than monotonous classroom discussions, what we were dependent on, or what excited us was that we started discussing case studies. So for the law point, we would teach, because when you come down to the pedagogy, because it gets related to the question, to the syllabus or the modules itself, excuse me, we started researching on the project. So we would pick up different countries like Portugal, France, Spain, and then relate it to, so we, as a teacher, I would always try and relate it to or sorry, balance it out with different legal systems. So it was very convenient, because initially we had taught them major legal systems, so it was very convenient for us to pick up a civil country and involve the other on the other hand, involve a common law country, because then we would see the individual fight, right of rights, with with the personalized fight of the courts becoming a party to it, because of the common legal system being involved. So we would devise, and then we would look into, because this is where we face the drawback, that there are certain countries where the rights, or where the choice of law was not available abundantly. So we would pick up examples of China, we would pick up examples of Chile. So certain countries that allowed us to create a very a varied uh, outline of laws to be discussed in projects. So that kept the papers plagiarism free also. That allowed us to discuss, and the students, because even if you don't remember what all you have read, at least that idea that this is what France, or the citizenship of France constitutes, and this is what the citizen, or what is going to be the right relating, or rights given to a wife in Bulgaria. Because there were so many laws that the students would come up with, that ma'am, in this particular state, the child is having these rights, what will happen if the conflict is going to arise in certain things. So you give them an idea, or you give them a canvas to draw idealistic laws as well. So that is why, we I understand that the papers of, like, your Indian Penal Code, or CRPC, they become very important, because they allow us to practice as lawyers. But conflict of laws is a magnificent piece of information, which allows the students to brighten up their days. So this is not redundant. That is why students really enjoy reading this also. The only drawback is there is too much to read. It's a very, very, very bulky subject, because there is so much of information, and because your syllabus gets restricted, you keep recommending extra readings. And we recommended novels also to people, because just to engross them, that if somebody's is life is lost, how the conversion from private international law will happen to into public international law, because then we had cases of Norwegian couples, we had the Australian Indian couple, then we had the German couples who could not go into intro vitro fertilization, or who could not adopt because the country was not agreeing to it. The international adoption cases of 2010, where the Britishers would come in and what do you say, uh, adopt children so that they can be converted into house helps. So you can go back into an old case, discuss it, and feel that what all has changed. Because when we used to discuss new paradigms, no, like e-commerce and uh, your online transactions, introduction of AI, because last year we spoke about introduction of AI into artificial intelligence, that what is going to be the scope of robotics, what is going to be the scope of citizenship of robotics. If Sophia comes into India, what sort of rights are we going to give them? If there is going to be an artificial intelligence manned diplomat, what is going to be the right of that particular person? Is it going to be private international, or is it going to be public international law? What happens to the AI which is not going to be considered as an individual, but is performing the contractual obligations of an individual? So there are still many unanswered questions that we have. But it was it brought out the amazingness into this. So I've discussed, like, what were the different points of law. The paper compilation also carries it. So the forums, the conventions, the arbitration that can happen, agency partnership companies, contractual obligations, individual in crime, how it becomes you know um, the what do you say, the basis of the private international law getting converted into public international law. And other aspect allowed me to talk about the as a teacher, arbitration for that matter. So again, as different tools of pedagogy, clinical legal education came as, or it was being, I'm little biased. I'm little biased towards legal aid. So clinical legal education brought out one of the best aspects of this paper. And I belong to old school, my dear friends. I don't believe in PPT. And this is where Kalpesh and I really clashed with each other, because in the morning also we were fighting. He said PPT, I said no PPT. So I adhered to him. I borrowed a PPT from Google. I did not create a PPT of my own. And I hope I can't see him now, but I hope he's laughing at me. So I uh, I don't bring PPTs to my classes. I'm a Socratic method, and I'm a lecture method person. And I've not mentioned it in my PDF, this word formulation, sorry, but I have practiced for the smaller groups, cafeteria method as well. So we have so many things. um, we've jumbled up so many things to bring out the best possible strategy. There are days when they don't want to be participative. There are days when they say that it is becoming too heavy. There are days when they're too energetic, to when specifically when they are talking about a country, and in the newspaper something like this also happens, or in the newspaper there's a private issue which they've noticed, and they would bring out certain things, ki ma'am, this is what has happened. So this is I for this paper did not allow me to use flip method or quiz method, or short answer questions, because majority of our effort was taken up by role playing, panel discussions, clinical education, because it allowed me to see that there is brainstorming that is happening. And it allowed my debaters also to speak, because they would feel as if they are participating in an MUN, and no regulations attached. So this is an humble attempt, my dear friends, of conflict of laws, how we've created a pedagogy, how conflict of laws rather allowed me as a teacher to create a pedagogy, and involve students in a system of growth. So I'm not teaching conflict of laws this year. Maybe I'm missing out on it. But then I'm teaching legal methods. So I'm trying to incorporate a bit of private and public international law into it. So it I keep the keep jumbling up the modules, and I'm going to be really really appreciative on record here of the system of at least the institutions that I work with, that it allows us to revise the paper um, along with the changing times. So I don't need to get dependent or restricted or apprehensive about any point that I want to believe in. So within, I've mailed Kalpesh sir another document which has been compiled by a university, and I found it to be really helpful because it talks about different units and how conflict of law can be a part of it. So rather than discussing my syllabus, I've tried to bring out, I've discussed how we've divided our syllabus into 4 modules. I brought out, a PPT which is talking about the how English rules talk about conflict of laws, because the conflict of laws is a paper which is very dear to the Britishers, and I've studied my masters there. So there would be n number of days when we would discuss such things and such conflicts through case laws, specifically previous case laws of Privy Council. So I hope that the reading material reaches out to you. I'll try and reach out. I'll answer out to all the questions that are pending here. But in case there is something that you want to reach out to us, please do not hesitate in contacting us. Whatever contributions, whatever suggestions I can humbly make, or whatever material that I have with me, I'll be glad to pass it on to you. So I hope, because it will only allow the students to win. So I hope that we can do. I can contribute or I can assist you in whichever ways you want. And if Kalpesh sir he allows me, uh, I can answer the questions now.
Okay, participant, if you have any question, please raise your hand. I will unmute you, or you can put the question in the chat box, so I will read out from there. Yes, please. One of the question is like students do not enjoy all this subject in India. It needs good teacher all more to make it interesting. These are and then there are no good books written with Indian perspective. So what are your views on this?
So I somehow, you know, um, the books, we have international law books, so many of them, but then conflict of laws is something which changes a lot with time, because there are so many amendments happening, and plus we have not restricted ourselves to some particular countries. So the lack of books is always going to be a drawback, but there is no dearth of material, sir. We've never faced any question, any query, or any component where the students have raised the issues that there's no material available for it. So whatever is possible, even if it was a newspaper article, even it was a case study, whatever we could gather, there was always abundant material online and offline to support the law. And we've always taken help of the constitutional law of that particular state, whichever we would bring in for a comparative excuse me, for a comparative study with any other state for that matter. So we need good teachers for every subject that is there, but I am very happy with the way we are dealing conflict of laws. And again, definitely there is going to be one particular one, never going to be one particular book, because the countries will keep changing. So that is my view on this, sir, that we can always depend on different amalgamation of material. It's not going to be one particular stream that you could buy, or that you could depend your guns on for conflict of laws.
Another question: can we study citizenship laws in this subject?
A bit of citizenship law, sir, because the complete citizenship law would come under the purview of public law. But what are your individual rights of marriage, succession, and what rather than the laws of the state, theft, crime, or elections, financial emergencies. So individual rights, whatever is concerned with the individual rights of the citizenship, definitely you can read it in conflict of laws. Agreed, Mr. Khan. Agreed, Dr. Khan. I'm really, that's why I said that I'm thankful. I cried the day they handed me conflict of laws, because they don't ask us if you're going to teach it. It's that you have to come up with innovations. And I cried that it is such a difficult paper. What am I going to do? But then I'm really thankful that this paper was given to me. And I cannot agree more with you. You're absolutely right on this, sir. Absolutely right. And I'm humbled by your wishes, sir. Thank you so much for at least being a part of this session.
Okay, so any other question, participant? You can raise your hand also. So how many? This is a like I hope this is an elective subject. So how many students they offer this subject, and how many sessions are there? So
Sir,
can you throw some light
initially,
on
sir,
that?
yes, sir. It's a 4 credit paper, sir. Initially, it was an elective paper, but now it's a compulsory paper, sir. So in one semester, we teach public international law, and in the other semester of third year, we teach conflict of law, sir. We teach public international law first, and then private international law. जब elective paper था, so we had around 50 to 60 students opting for it. The very first batch had only 22 students, but then now it has a compulsory paper, sir.
Okay, okay. Okay. So let me tell you, first time I'm listening to this topic. Frankly speaking, I studied very small law college, let me tell you, and then obviously hardly we studied the basic subject, so we cannot think about this particular law. And while discussing with this, with you, and then I would say pressurize you, please take this at least, one can get to know. I don't know uh, how many faculty members they are know about this subject and teaching. I'm very like I'm sure, like definitely. And you're telling it's a compulsory subject, right? So I think more than that, okay, elective seminar paper, that is fine. But can being the compulsory paper again, it's very commendable job. Obviously, teaching will be the hard. And some they're asking some good books that you would like to suggest. The last question, then we'll wind up.
Sir, I'll send across the list of books, sir, to you so that it can be for passed on to them, because then
Yeah.
they can pick up the different components from different books, sir. There's a list of readings that we have drawn for conflict of law, sir. I'll be happy to share it with sir.
Okay, Manish. Okay. Thank you very much, ma'am. Let us, I think, I'll already share your material with all the participants. I hope they will go through it and they can also
Sir,
plan out. Yes, yes, yes.
sir, sorry, but Dr. Khan says that teachers can practice this in regular compulsory papers to make class more interesting. But for family law, agreed, sir. Sir, for law of property, Dr. Khan, Ashutosh, sir, thank you so much. It's Dr. Khan, you're absolutely right. So in case there is no one particular paper, it can law of property can also incorporate conflict of laws, family law, arbitration, sir. So arbitration can talk about in a bit your jurisprudence behind conflict of laws and how arbitration is beneficial for forum sharing. So bits and pieces definitely can discuss this paper, sir. Companies law, absolutely right. Mercantile law, absolutely right. So I'm so glad that such a positive approach has been presented by Dr. Kalpesh and you. Thank you, sir.
So definitely, this is,
Glad.
I think, this will the outcome of this particular today's session. So we can, whichever subject we are teaching, we can include. I think we can discuss. I think maybe 2 or 3 class. Okay, this kind of things also can happen. We cannot like
Ji.
okay, we keep trying like while teaching particular subject with another Indian law, not the foreign law, but again this we can like family law, arbitration, companies act, property, or any other things. I would say
Absolutely.
there may be possibility of more than half of the paper we can discuss this thing while teaching and discussing this particular law. So thank you very much, ma'am. I request Dr. Vidisha to give a formal word
Sir,
of thanks
before
to you.
that,
Over to you, ma'am.
I'm really sorry for interrupting you, but I wanted to thank Mohit K. Gupta from UPS for at least showing all the interest in the paper. Thank you. Over to you, Kalpesh, sir. I'm
No, no, no,
sorry
no,
I won't disturb
no,
you.
sure, sure, sure.
Thank you.
Okay,
Thank you
thank
very
you,
much,
thank you.
ma'am. Thank you for sparing your valuable time and enlightening on a very interesting topic. And Kalpesh sir is right that this is a subject where all the faculties are little bit hesitant in taking the subject. But yes, in our college also we have experienced that students have now having interest in the topic. Thank you very much, ma'am, for enlightening that how it can be correlated with the property law, contract law, adoption law, surrogacy law. So thank you so much, ma'am. Thank you, Kalpesh sir, and the whole team for making this FDP such a nice. Every day we have interesting topics to learn. And thank you to all the participants for a patient hearing. Thank you very much.
Thank you. Thank you very
Thank
much,
you.
ma'am.
Thank you
Thank you.
so much,
God
ma'am.
bless you. Sure.
Thank
Thank
you,
you very much.
Bhupesh
Thank you.
sir. Thank you,
Thank you.
everyone.
Thank
Have
you.
a good night, please. Thank
Yeah,
you.
good night. Okay. Thank you.